Welcome to Secura Law Experience. I'm Luis Elizalde, founder of Secura Law. I'm here with
Stephanie de la Millar
and Eduardo Borgar.
Perfect. In this episode, again, we are looking to speak about the closing process. We were looking to do it every 10 episodes, but I think it's really good that we speak again about that because you never know. It's always good to have the information, and you can see that the information is not going to change, never. Maybe the way that we explain it is going to be different. So the interpretation, if you hear it in the last episode when we spoke about the closing process, the idea is the same. You know, it's not gonna change a lot. At the end, it's law. So
yes, but maybe we can keep addressing with the experiences that we have, no?
Exactly.
Every time that we have a closing, there is a new knowledge to be learned. So I think that it's why it's very useful to have different approach about how to explain the closing process.
Totally agree with you because it looks like all the closing process is like a process. It's not going to change, but every experience, every closing is different. The people, the broker, the attorneys, the contracts, the agreements, everything is different. So the main idea is to explain general points, and maybe we will have questions in the future from everybody, and we start doing that, responding that question. You know, so
definitely. I mean, I think we should start from the beginning, as it should be, from the first step, which is the due diligence. In my personal opinion, I always tell clients that I'm really their legal doctor, and in order for me to give them a good X-ray of what the closing will be, I need to check it in the public registry, right? That's how I'm gonna be able to see everything that I need to be able to trace the plan, the perfect plan, for everything to happen smoothly and without any issues.
When you begin the due diligence, what do you need first?
Okay, for the due diligence, usually we always have already an offer letter signed.
Okay.
And a deposit made. And that's when the seller provides us with the legal documents of the property to be able to look it up. Basically, what we need is the deed with the registration ballot.
Okay, that's good. In the Spanish, it's boleta registro.
Exactly.
Perfect.
Yes, and there you will find the electronic folio number if it's a new property, and if it's an old one, it's just the folio number. Yeah. And it's how you go to the public registry, which is an institution, and you can look it up and you'll find all the history of the property from the first owner to the last. What
we can find there in the public registry when you do
what we can find, basically every movement that the property had since it was first purchased in private property. Basically, if we have a trust, cancellation of trust, a mortgage, cancellation of mortgage, a purchase and sale agreement. If we have a trial going on, we will see there. Every movement you can think of, you can see it, to see what happened or what is happening to the property.
That I think that's the important thing of the due diligence, to know if the property has any lien or encumbrances, right?
Yes.
Perfect.
Yes.
The legal story of the unit itself, legally speaking.
Yeah, because that is going to be the main factor on how we are going to plan, first of all, the contract, because we need to add things up there if needed. Let's say if there's a mortgage in the public registry, we need to address a clause in the contract stating that the seller will cancel that mortgage to convey the property over to the buyer free of liens. All that has to be there.
Perfect. So, by your experience, how do you define the due diligence? Like the short version. What is the due diligence?
The due diligence, to me, is the most important step to look after before engaging in a real estate transaction.
Perfect. For you?
Yeah. For me, it will be like the map of the transaction, how we can design the pathway to that will lead us to the very end.
Okay, that's good. That's good. Awesome. And after you see that we realize that there is no issue in the property, looking in the public registry that is free of any lien or encumbrances, what is the next step?
The next step is to give the client like that update, which we call title report. So they
Okay.
can see that and we translate it into comprehensible words.
Okay. Yeah.
Because all we see is legal stuff. So after that, then we move forward into the contract, right? Now that we have the full picture of what we have to address, what we need to take care of, what is good or not, that's how we can start drafting that contract.
Okay. How many? Sorry to interrupt you. How many steps we are looking in a closing process?
5.
5 steps. Okay.
Yeah.
And-
Usually.
Exactly. Usually.
Yeah, exactly. Then, like the big picture,
Yes.
the general idea
Yes.
will be 5, of course.
Yes, but sometimes we have closings that we get in the middle, from the beginning, at the very end.
Yeah, totally agree with you.
Yeah, but the main thing is everything has to start with the public registry because that's our insurance, if you may.
Yeah.
Yes.
Perfect. So the first step is gonna be due diligence. The second step,
The contract.
and what can you say about the contract?
For me, basically, it's the rules of the game.
Okay.
For the buyer and for the seller. It creates clear terms and conditions regarding the transaction. So for buyer, it's very clear the payment schedule, who the seller is, if it's legal represented, and also the timelines to get the physical possession, to get the title, and what happens if the seller doesn't comply with all their obligations as a seller. There will be consequence, whether is the legal enforcement of the compliance of the contract or penalty or some type of compensation. And for the seller is the same. It creates very clear terms about when and how much it will be paid, the payment method that we will use through the transaction, the timelines for the buyer as well to get the title executed, and the penalty for the seller in case that the buyer doesn't comply with the contract.
What is the normal penalty or percentage or amount that it has to be in the contract or in the promissory contract for both? Because it has to be an equal contract, right? Has to be both the same for both. What do you think is the best percentage or amount as a penalty?
I mean, we are very used to or ruled by custom, and the custom here is 20% of the purchase price. That is the average. Sometimes it's less, sometimes it's more, but that is the average,
Like
and we are led to that.
The starting point.
Exactly.
Okay. That's good. Any opinion about?
Well, in my opinion here, I always get a question when we step into the contract because usually people think that they already signed it when they sign the offer. That's a common very misconception. Yes, the contract will have basically almost the same clauses or obligation as the offer letter, but we add some things more, right? Because usually in the offers, you don't see any penalties. You don't see any obligations regarding the closing documents, who's going to provide those, who's going to cover the cost, let's say, for the capital gains, any other taxes, notary fees, what notary will be used for the transaction. So those kind of things are refined in the promissory contract that are not included in the offer. And something that I get also a lot of times is, well, if I already signed an offer and then I have to sign a contract, then is the offer an enforceable document or it's a binding document. That's why they ask. But I mean, it's very clear in the offer. It says usually 15 days, right? So you're good, and you can you're binded to that for that period of time. If out of that time you don't get into a promissory contract with both parties, then nobody is like binded to each other.
I think you just said something very important before the closing process in the offer. When you sign an offer, you have to be sure that in that offer, that 15 days or the term that you have to sign a promissory contract, you already made a deposit. That deposit has to be 100% reimbursable. That's the normal thing to do and the safest way to do it.
And the right thing to do.
Exactly.
If you see it the other way, don't do it.
Yeah, exactly.
It usually ends bad.
Yeah,
Yes.
yeah, because sometimes they keep the money, and I already told you it's 15 days to sign. If not,
Yes.
what?
And they could not even be interested in actually selling.
Yeah,
They're just
exactly.
fishing for money.
Exactly. It could
Yeah.
be a scam. I mean, it's like if you are getting a date when you are meeting someone, that will be the first red flag
Yes.
to run away, no?
Yes.
Yeah. So be sure that in your offer is a sentence, a paragraph, or something saying that the deposit money is 100% reimbursable. If not there is a red flags.
To what I see, and I've asked a lot of brokers about this, is usually a lot of agencies, they keep that deposit. So they are the ones responsible for returning it. They never give it to the seller.
Okay,
To
that
avoid
could
these
be
kind of
good.
issues.
That could be good.
Yeah.
Through that, to run an escrow account, that could be.
Yes.
That
Once
could be.
the promissory contract is signed, that's when the agency now gives that deposit
money to the seller.
and the down payment from the buyer. right?
Totally agree. Yeah, but doesn't matter if the agency or the agent take the money
Yeah.
as a deposit.
Mhm.
But the important thing that the offer has that phrase,
It's reimbursable.
Yes.
that has to be 100%
Yes.
reimbursable.
Definitely.
So okay, going back to the to the second step, the promissory contract. Fast definition of the promissory contract. Any idea?
I like the one that Steph said, that is the rule book or closing guidelines, because that's where we're going to have everything, every responsibility, obligation, penalty, situation that may or may not occur during the closing. We have to put it there.
I will set, in addition with that, is that it's a promissory contract. Sometimes the client, by experience, they think that they already signing the title, you know. Yeah. And when we explain, no, this is promissory contract. That's the reason of the name, because we have to work with the next steps. So meanwhile, we are working with that, we cannot sign a title. That's the reason the name of the contract is promissory contract, because you are committed to do a future action. So that's important.
That's super good definition.
It's in the book.
Yeah. Yes. But I mean,
Yeah,
you know,
exactly.
in English, I think it's a very, very good translation.
Yeah, exactly.
Yeah.
So
Yeah, because basically what we do is a future thing, because the trust paperwork, the taxes, whatever that we're establishing in the promissory contract will take a few days or a month and a half to complete.
That's good
why
one.
it's a future thing.
the time, because that's the normal question that we have for the client. Hey, how much time it's gonna take? And normally years ago, I think it was like 90 days. Nowadays, it could be in 5 now. No, not possible
Let's
in
say
5.
30 to 45.
Yeah, exactly.
That's the norm.
That's another thing that you can look. The closing normally is 45 days, because if it's an assignment or right, it's a new trust, whatever, there is document that you need to gather to have a really smooth closing. So something less, or someone telling you less than 45 days is possible, of course, but a lot of things has to be there to be possible. So be sure that makes sense all the time frames. Minimum 45 days. Maximum, I think 90 days. And of course, could be exemption that is going to be more than that, but that depends on basis in every case.
Well, the specifics, because sometimes you have people that are supposed to come down for the closing, but they're not able to.
yeah.
They have to reschedule.
Mhm.
I don't know what else could happen. Some closing documents weren't issued the way they're supposed to, and we have to fix them.
Yes. Someone dies.
Yeah, there's a lot
Oh.
of variables there.
Yeah, that's a big difference because they think because I already signed the contract, it's gonna happen, but they are not consider the human part. You know, there is a lot of things if someone pass away, if the municipality have a typo in the documents. You know, it's yeah, that kind of little things that is behind the scenes. I think that the buyers have to consider that, and it's not risky. It's just matter of the process.
Exactly. The key, again, I think we always say that, but the key is communication. The attorney has to inform you about a new sudden situation that could affect the closing date. And based on the situation that we have, most of the times we need to execute an amendment agreement. So again, all the parties know and are aware that some terms or some dates will change because of an unexpected situation.
Exactly. Perfect. So after we sign the promissory contract, okay, we already, the seller buyer agree with the terms, condition, penalties, everything related to the promissory contract. Looks like we can move forward to the third step, or the next step, that is the third, of course. What is the third step? You know,
It will be the contract, the title execution.
the title execution or the trust?
Oh no, I'm sorry. I forgot.
No, you didn't forget. You were thinking about like a
Mexican.
like normal
Yes.
sale and purchase agreement.
Yeah, forgot.
But
You're
the
thinking like a Mexican.
For myself.
That sounded wrong. Sorry.
I'm in the middle of my own closing,
Yeah,
so
yeah.
I'm thinking attracting,
exactly.
you know, Tyler, come to me.
yeah.
Sorry,
that idea.
yes.
So no, the next step I think is the trust.
Yeah.
Or now I'm sure that is the trust, the formalization of the trust. And I think I'm gonna give a little idea that sometimes the client, they feel like the trust or fideicomiso is the same trust that they know in United States or in America or in Canada. But the trust that we have here is only for residential purpose, restricting zone. So that means that is only for the purpose of that house. You cannot put money there. You cannot use it for another thing. And something that just realized that sometimes, or not sometimes, in America and Canada, they put names on the trust. In this case, it's not like that. It's a fideicomiso. The real name is fideicomiso. We established the translation of trust only so you can understand a similar idea. What is it? That is gonna be through a bank. But the real name is fideicomiso, and it's only for your house and your property or condo. So I just want to be clear with that.
Yeah, I mean that's a cultural difference, right? And we need to explain it to them because they are used to the way that the things are done in their own countries. But basically here, the setting of the trust, which is the third step, it's not actually where it culminates, you know, because the third step is basically processing all that we have to do with the government officials of the Ministry of Foreign Affairs.
Exactly.
We need to set up the documents of the new client of the bank, which is the trustee. And at the next step, that's where we like finish everything and put everything together. But this step is where we start working on that. And usually, well, not usually, it's mandatory for the seller to have all the legal documents ready for that step to start, because that's very important. People think that we can start doing it right away.
Yeah, exactly. And in not the idea. That's the thing that we were saying about the time frame. Because of all of that document that we have to gather. But in this third step, the most important is the truth is pay the trust. in that moment, yeah, because we cannot say pay the trust at the beginning or before the promissory contract. Why? What happened if you never sign the contract and you already pay a trust or the bank? So that's the reason after you sign the promissory contract, you can pay the bank. And in that moment, everything, we're going to send the documents, we're going to send everything to the Ministry of Foreign Affairs, we are going to look to get the permit. Sometimes the client are worried saying, hey, but what happens if I don't get the permit? That's not going to happen. It's just a formality that we have to cover. And that's it. It's only it's a matter of process to get all the documents with the authorities, the bank. And after we get it, we can move forward with the fourth step.
Yes, actually, recently I had a discussion with another lawyer about saying, okay, you know what? So we can move forward in the process. I know that we haven't signed the contract. However, what if you start instructing to the trustee bank to assign the rights on my client's behalf? So we can keep the pace. Yes.
Wow.
I mean, he was like, you will have the documents. I won't see it, but I would like that you start the process before we sign the contract so we can close earlier than expected. And I don't know what you think. I mean, who knows? He can get access at some point to that document, and even though we haven't signed the contract, instruct to the trustee bank to assign the rights. Another thing is, what happens if the deal falls apart? We already made our client to spend resources, time, getting this document, because normally it has to be notarized and apostilled. So.
No, and you already create a precedent, like writing an instruction letter to the bank without signing the promissory contract don't make sense. You need a promissory. No, it's total. But
that is another red flag.
Totally, no. Oh my God, the way that they feel like it's very simple is. It's okay. You have to keep everything simple. That idea is a really good way to be in your life. But at the end, you have to fulfill all the formalities. That's the important thing. That's the reason they are hiring us. So it's kind of weird that that attorney, I don't know who is it.
I don't want to disclose.
No, that's okay. But that he's not aware that the first is a step by step. It's simple. Sign the contract. Everybody's happy. Everybody understands their obligation and rights, and then we move forward. So.
Well, it's because it's an assignment of rights. What I will tell the guy, then you pay the trust. Then let's kill off my trust with an extension, but you pay yours.
Exactly.
If
be
you
a good
spend that
comeback.
money, I will do my part before.
Okay. Yeah.
But in that specific case, you are letting your clients in a little bit of a risk for doing that and spending the time and resource, and they don't have to do anything because they're getting the trust assigned to them.
Exactly.
But if they have
And
to
there is an
create a new
instruction
one,
letter
Yeah.
without a promissory contract. That doesn't make sense.
Yeah, you need to walk before you run.
Exactly. Totally agree.
Yes.
So after we have the permit, the Ministry of Foreign Affairs, after the trust, something very important. In that moment, we have the permit, but that's not the trust. That's not the fideicomiso. Everything, as Eduardo says, is going to be in the next step. That is now.
Now, yes, it is the title. You see, that's why it's very important to repeat.
Exactly.
You can forget. Yes, the title execution. Obviously, all the arrangements that we have to do in order to be ready on that date and establish an official date for the closing. It could be actually before the day the contract says. We normally draft the contract saying that will be on or before, which means that date will be the deadline to execute the
latest,
contract.
yes.
And that, legally speaking, it is important, because in case that for very negligent behavior for any of the parties, we are not ready for that date, the party that is not ready will be in compliance of the contract. And legally speaking, that is very important, because obviously then comes the penalty if that happens. So we have to make sure that both parties have all these pre-arrangements, whether it's the trust itself, the power of attorney, all the pre-closing documents, personal information from them, proof of address, identifications. There are plenty of documents that we need to be prepared in order to have the draft of the title to be authorized by the trustee banks as well. So it's
a lot of things. Exactly. And we gather all of that, and we establish that in one document that is going to be like a big Bible. Bibles are big, but in this case is unbelievable, because you have in one document, you have your title, your trust, in fact, it's a contract of the fideicomiso with the bank in that title. So it's all the information that we already said, or Stephanie already said, that is all the pre-closing document, the permit, everything is going to be on the back of your title. So it's a lot of information that is going to be there. So that's the reason it's going to take some time. And after we got the draft from the notary, we need to send that to the trustee bank and get the approval. So yeah, it's a lot of things.
Definitely. Here is like where everything clashes together, because from the contract we established the pre-closing documents, they're going to be there. How the money is going to be paid, established in the contract, that's going to be there. All the work done in the trust part for the permit of the Ministry of Foreign Affairs and everything, that's going to be there. So basically that's where we bind everything together to close up the deal, basically. And very important, this document has to be signed personally or through power of attorney. So that means people have to be here. It cannot be signed by DocuSign or scanned, nothing. It's a formality that our law system has.
And I think it's good. Mm-hmm. You know, promissory contracts, different kind of contracts, you can do it by DocuSign.
Yeah.
It's not
private, no?
Yeah, exactly.
The private
that
ones.
doesn't mean that we are in the arcade or we are in old school. No, but in this case, for titles, and to be sure that everything is according to the law, I think it's so correct that we have the public deed and the last step, that is the public registry. I think after we sign the title.
Oh, yeah. This last step is the one that will ensure that the process was done correctly and that the title will be registered in the public registry. Because all the documents that were issued prior and are in the public deed will be also sent to the public registry to be registered. This part takes around 3 to 6 months, basically, because obviously there's a big load of work in our area, basically in the Riviera Maya, and that process has to be done correctly. So they have to review every single document, and now they have like an electronic system, so they have to digitalize everything, so any of us can go directly to their computers and do our due diligence there.
Yeah, exactly.
So
and look, the
if
system.
you see, we're back at the beginning.
Yeah, the full circle, as always,
circle.
As you said, always. At the beginning, the due diligence starts in the public registry, and the last step is again the public registry, when we are sure that your title is duly recorded in the public registry. So that's the closing process in general. We already spoke about that, but I think we can speak a little bit about the specific that something came out, or I'm thinking. One, the penalties. I already have the experience that the client thinks, okay, because it's in contract, I can request the penalty the next day. Yes. And that is not work like that. And you can think, in Mexico it's not going to work. Or if I go to the courthouse, it's not going to work. No, in Mexico it's work. The courthouse is really good. The justice process is good. The only thing that we have is the slow process. It's going to take time. But that's also the reason in the promissory contract, you will find that there is a time after you are breach of the contract, the one that is not in breach of the contract has to notify the other party, and the other party has between 10 to 30 days to solve that or to fulfill the obligation. That's the reason we establish a term, because sometimes it's just communication. Sometimes
Yes.
it's just, okay, I have to send 100,000 and I send 90,000. Sorry, I'm going to send the 10,000 more. You know, that little things that
Exactly.
we have to be very clear, or you have to understand that you cannot be like, I don't know, like Old West, that you can, hey, give me my money. It's not like that. You know, you need a judge to rule that, hey, okay, he's breaching the contract. Why? Because of that
Yes.
reason. And it's very easy to find out. Hey, you have to pay 100,000. You pay 50. Of course, there is a penalty because you miss money. It's very simple because it's
Yes.
transactions. So if you don't deliver never the unit, of course, there is another penalty.
Exactly.
How can you show me that I didn't deliver the unit? I don't have the keys. I don't have possession. You know, that kind of thing.
Yeah.
But they think that it's very simple to ask, or, hey, give me my money back right away, or give me the penalty, pay the penalty. Not like that. You have to be aware there is a process. And sometimes it's better to have a really good negotiation, an agreement. Maybe the worst case scenario could be a termination agreement in which, okay, maybe not going to be 20%, but you have an agreement with the party that breached the contract to pay something. You know, that idea, because at the
Yes.
end,
Think about that. Maybe you won't get the 20%, but you are saving on litigation process and litigation attorneys and cost of filing your lawsuit. So maybe that will cost you roughly $10,000. So you are saving that part and also saving a lot of time, because, as Luis said, it's not that our system of justice doesn't work. The thing is that it takes time, and also you need a solid argument to claim for the penalty. It's not like, I don't like the unit anymore. Oh, well, bad luck, maybe you didn't make the best investment, but it's not a sufficient reason to claim for a penalty. Yesterday, I got an email from a client saying that he was very scared about some news that he read, and that he wants to terminate the contract and claim for the penalty. And if that could be a major force. You
okay,
know?
consider as major for.
Yes, and I mean, it's hard. If you want to ask for a rescission, it's because the other party is in breach of the contract, and having read bad news about something, it's not a reason, a solid one, that the judge will admit.
Exactly. Because at the end, it's news and there is no facts. You need facts. You need a notice. The most important thing, I think, for the penalty is you need a notice. You need to be aware that the other party is aware of the breach of the contract. It's very simple, and in the promissory contract, it's established like that. So it's possible to get the penalties. Yes, I'm not saying, because I already hear another. Normally they are agents. So what's the reason of the penalties? You know, you cannot claim it, but it's not the reason that you can charge right away. That is, you need a process. That's the reason everybody follow the laws. You know.
Exactly.
Definitely.
And that was an idea of penalties. And one really, really fast that I think we also have to speak a little bit is the pre-closing documents, the certificates of that. Sometimes, or normally, the 99% has to pay by the seller.
Yes.
Why the 1%? When do you think is that's
When
gonna
the
happen?
buyer gets possession of the unit prior to the closing.
How prior like
sometimes we have to do this because it's the only way for the closing to happen. That's called a soft closing. It's when in the contract, in the promissory contract, which is the second step, we actually, because of the situation of the closing, establish that the buyer will get physical possession, not legal, to the property. And then after a couple of weeks or months, we in the fourth step, which is the public deed, that's when they signed off all the documents and get the legal possession. So in these kind of situations, since the buyer is in the house and is living in it, they have to take over all the expenses, and that means also the closing documents.
Okay.
That's one of the cases that the buyer pays for that and not the seller.
Exactly. That and it's very clear. You are using the house. You have to show that it's free of any lien, you know?
Yeah.
How come the seller that is not in the possession of the house, that is not aware of the bills or everything, what is the reason that they have to pay it? You know, that little things that make the huge difference.
Yes.
So it was only that. I was just to be clear on that.
Yes.
Definitely.
And also it could be that the seller already filed for all these pre-closing documents, and because the buyer is not able to come to closing, that it's important.
Good
The
one.
pre-closing documents have a validity.
Mhm.
So if by the time that the buyer is able to come to sign the title, those documents are expired, then obviously it will be a responsibility of the buyer to renew them.
Yeah, because the seller already fulfilled the obligation to deliver.
Mhm.
So if he delivered, but the buyer didn't arrive, it totally makes sense.
Definitely.
Okay, I think that's the big general idea. Please send your questions if you have. For sure you will have. And we will be glad to answer that. Thank you so much.
Thank you, guys.
Bye.
Bye.